Daniel, while making that point about legislature and the judiciary, many also think, I beg your pardon, and the executive, they think, look, the moment they're on the same page, forget about all of these breakbacks. They will do whatever they want. They say, look to the states. Which state legislature has disagreed with the executive arm of government? As we see today, the answer, many think it's not just there. So should we go ahead of ourselves celebrating that, well, yeah, we actually need that independence, or does it even exist amongst them?
At the state level, it will be doubtful to say whether there is actual independence, between the legislative arm of the state and the executive. Sadly, the governors have the national assemblies of the states in their pocket, which is a very worrisome thing. But at the national level, I think there is independence. I want to let you know, Chamberlain, that the Constitution is binding on everyone. If you look at Section 88, Section 80, right up to Section 88, you will see that the National Assembly, apart from the powers that they have in Section 4, which is lawmaking, to make laws which the executive must implement, in Section 80 and in Section 88, you see the oversight function that the National Assembly has. The National Assembly actually, if they are on their toes doing their job, it is the executive that should be afraid of them, because the bulk of the work lies on the National Assembly. They have oversight functions over ministries, departments, and agencies of government. They can summon, they can inquire, they can investigate. And secondly, they have also control over public funds through the consolidated revenue of the government, which means even the executive cannot spend 1 naira without appropriation by the National Assembly. And we have seen in the past, recently, with the passage of the bill and the appointment of ministers, that the National Assembly, when they are ready to do the work, they can do the work. For me as a person, I will be worried the day the executive and the legislature are having a very, very good rapport. Because when that happens, then that means the destiny of this country is being mortgaged. Look at it critically. Behind all the hula balloons and the crisis, public interest of individuals, not the interest of the country at stake. So what we want is the interest of the country to be much more paramount than the interest of the few cabals who are having these problems. If you are charged, go and face it. You have powers, and I do not think the presidency in any way in recent time has shown any attitude that suggests that he is interfering with the functions of the legislative arm of government. Interference, criminal trial is a separate thing. It has nothing to do with interference. If you are charged, go and face it. And people are being charged every day, don't forget. And the rule of law is where everybody is everybody is not above the law. So that's my take on that.
You lecture, you're a lecturer also of law at the law school. Perhaps what would you be telling your students? You just brought the issue of bringing up immunity, and which boils down to constitutional amendment. If we look at the office of the Attorney General and Minister of Justice, which is another key issue here for some close watchers, they still think that that argument of separating that office has again come to the fore. What would you be saying to students and other colleagues of yours?
I'm sorry, in the last 20 seconds, the microphone went off from my side. I did not hear what you said. Can you repeat that question again?
We're looking at the Attorney General and Minister of Justice, the office which some have said is always coming into conflict when issues like this come to the fore.
Right, I agree. And I also subscribe to the call for the separation of the office of the Attorney General and that of Minister of Justice, because the Minister of Justice gives you all the political intricacies, but when you are Attorney General, then you should do that. But you see, even in England and in America, you cannot divest the influence of the executive on the Attorney General, because the Attorney General is an appointee of the President, and the Attorney General is at the pleasure of the President. And even though in principle, Attorney General can investigate the President, but whether that is possible, it remains to be seen. And then you see also that the office of the Attorney General is such that it's so enormous that even the Inspector General, that's the police, the EFCC, the ICPC, and all of these other agencies of government that prosecute are under him. I think that the fact that the Attorney General also operates as the Minister of Justice does not mean he cannot be effective. While we advocate for the separation, but even before the separation of the office into two, the Attorney General should be able to carry out the function of his office. I know that these questions have been coming up because of the fact that the Attorney General was the one that initiated the idea of the prosecution of the Senate President Ekweremadu. Rightly so, it is lawful. It is on the basis of the report submitted by the police. And so the Attorney General in the circumstance can initiate that. Remember, the Attorney General can initiate, can take over, and can discontinue criminal trial based on our law. So I think it's within the ambit of the law that is doing that. Even though I have reservation on so many things, about the office of the Attorney General, I have reservation. But, as far as this issue is concerned, I think it's on course.
I'd asked you that question about whether or not this was politically expedient, and well, maybe not politically, but expedient at all. In the face of all the other cases, you talked about the Administration of Criminal Justice Act, which has been passed, and it would seem that it's not been applied in many other instances. Shouldn't the Attorney General be more worried about other ordinary cases that, will involve the everyday common man, and his impact to be felt more there?
I agree. And I agree. Let me even tell you this, Mark. Sadly, I don't know if in recent time they've started making use of the lawyers in the Office of the Attorney General. In the past, the Office of the Attorney General consists of a lot of lawyers who just go to office and sit down. And then briefs are given out to private practitioners. And these lawyers in the Office of the Attorney General are not engaged. So many programs were initiated in the past, like prison decongestion, and so many other programs like that to look at the administration of criminal justice. But don't forget that Attorney General is the chief law officer of the country. It is not only limited to criminal matters. The Attorney General should be able to advise the government on matters relating to law or legal implication of the official act of government. And whether this current Attorney General is doing that remains to be seen. And that's why I said I prefer to say I have a reservation in that. But the Office of the Attorney General, if fully functional and functioning within the ambit of the law, should be able to address the issue of the implementation of the Administration of Criminal Justice Act. It started with the past Attorney General who came up with the idea, and individuals came up with the idea, and then they piloted the passage of that law. And take a look at Administration of Criminal Justice Act. If we are actually implementing every bit of that, we won't have problem of criminal trial in Nigeria. Right. But it seems that lots of people are not yet aware or familiar with the provisions of the Administration of Criminal Justice Act. And to be fair to the courts have been trying in recent time to take into cognizance the application of the Administration of Criminal Justice Act, which is the reason why in recent time, especially in high-profile cases, you see trials going almost every other day.
I need to butt in because we need to wrap up real soon. But let me ask you this one, and make it brief if you can. In this kind of case, if hypothetically, what if the Senate President and the deputy say, listen, we're not aware of all of this, we didn't forge documents, we just met a document on ground and used it. So will they then listen to him and think, well, they shouldn't be the ones, it should be the clerk?
Well, the thing is, when a matter is in court, we try as much as possible to refrain from making comment as to the propriety or otherwise of that. But I know that if you are taken to court on account of conspiracy and forgery, all you need is to go into the court and expect the prosecution to prove that you actually doctored the document. And if you never did, then you are free to go.
Daniel Bola, legal practitioner, appreciate your thoughts this morning. And that's where we also draw the curtains today on the program. We appreciate all your comments as well. We will be back tomorrow as always. Thank you for watching. I'm Chamberlain Oso.
Well, thank you for all your messages. Welcome back.
Welcome back, right?
Yeah. Thank you. I'm Maokwe Ogun.
Many thanks, Sulaiman. And see you again.